So we were doing probate and administration 2015 question, and we were at question 1, where a man has been gunned down in 2014 and the man has decided to leave a will. And before leaving this will, the man had two widows, and each widow had two children. So if you look at Roman number 1, he has decided that he is bequeathing his palatial home in which they lived to his first wife Kanjora and her two children, to the exclusion of his second wife Lydia and her two children. So we can say that this will is already excluding the other wife from inheritance and his children. Then we can also see a bequest to his mother Mariosa. We can also see a bequest to Jemima. We can also see a bequest to his brother Jerry. We can also see a bequest of 100-acre piece of agricultural land to his friend Joshua. So the question basically demands you to advise the validity of the will and its effect on his beneficiaries. So to answer this question directly, because we had read out the question, there was how I had tried to break down the same. It is opening in a few. So basically what you need to understand is that the will is not automatically void because Mr. Tito disliked Lydia, but it is vulnerable on the following issues. One, we have testamentary capacity and validity challenges, and a court-ordered reasonable provision claimed by Lydia and her two children being the dependents. So if the will is upheld as formally valid, the court can still vary or displace its effect to prevent unreasonable disinheritance, especially in a polygamous family setup. So various angles that you have to master is that if you look at section 5 and 11 of the LSA Act on validity and capacity to make a will, a person may be disposed of their free property by will, but must have testamentary capacity, be of sound mind, and the will must comply with statutory formalities, where you have the signature plus attestation by two competent witnesses. The reason why you have to state that is because from the question you have been told that this person had a memory lapse. Then you have reasonable provision. This will limit testamentary freedom. If you read section 26, 27, 28, and 29 of the LSA Act, even where a will is valid, if it fails to make reasonable provision for dependents, the court may order reasonable provision out of the estate. So the key factors that you have to consider, we have the nature and amount of the estate, the dependent needs and means, prior advancements, and the circumstances of other beneficiaries. Then, because the question has also directed us to analyze article of the Constitution, we can quote Article 27 on that dispositions and succession outcomes must be read consistently with the constitutional equality and non-discrimination and protection of the family setup. So, e.g., not excluding children and daughters is unconstitutional ground. So basically, to answer the question as per the examiner's request, is that we can start with a bequest to Kanjora and her two children when it comes to the house property and the executor appointment effect. So the will said that they take the Nairobi palatial home as devices, and Kanjora is entitled to petition for grant of probate as the executor. So what is the main vulnerability that the examiner expects to see? He expects to see that Lydia can seek reasonable provision pursuant to section 26 of the LSA Act, because she and her children are prima facie dependents pursuant to section 29 of the LSA Act. If the home is the main matrimonial residence and the other house is left destitute, the court may order provision out of that asset or other estate assets, reducing Kanjora's effective benefit. So practical outcome, we can say that Kanjora's title may be delayed or encumbered pending the determination of Lydia's objection and or section 26 application. Bequest to Mariosa being the mother. This was the Njora farm that is in Nakuru. So effect is that the mother takes the farm subject to proof if it is Mr. Tito's free property and not excluded by prior transfers or encumbrances that the deceased could have engaged into. So the risk is that if Lydia succeeds in either one to invalidate the will for incapacity or B on reasonable provision requiring distribution, this bequest may be reduced. Which bequest? The bequest to the mother. Because And B, that you have to take note is that a parent is not an automatic dependent unless being maintained by the deceased immediately prior to death, pursuant to Section 29B of the LSA Act. So if Maria Rosa, being the mother, was maintained, she strengthens her footing even against Section 26 reallocation pressure. So that is the theme that the examiner expected a student to master. Still on this point is that if a person has decided to take a permanent responsibility of a child, then that child must prove that at the time of the deceased person, at the time of the man dying, he was still being maintained. Contract that to if the beneficiary was a child that has been legally adopted by the man, because in that situation the legally adopted child will have equal rights as the beneficiaries, other biological beneficiaries of the deceased person. The bequest to Sister Jemima, being the fish pond goats at Kile Farm in Kitale. The effect is that Jemima takes these specific gifts. So the risk is that, like the mother's gift, it is vulnerable only if the will is invalidated and the court needs to carve out property or value for reasonable provisions for Lydia and her children. Generally, courts try to satisfy Section 26 provision from the estate without unnecessarily disturbing specific gifts, but they can do so if needed. So the examiner expects to see whether you can appreciate the angle of bequeathing somebody a gift during your lifetime or inside a will. So bequest to Brother Jerry, where he was given shoes, suits, and a car Pajero KCF on 20 CD. The effect is that Jerry takes the chattels and more vehicles as specific bequest. These are typically easier to transfer and may be less central to dependent provisions, but if the estate is otherwise insufficient to provide reasonably for Lydia and her children, even movable assets can be brought into account. Bequest to friend Joshua, being the 100-acre agricultural land. The effect is that Joshua takes the 100 acres as a stranger beneficiary. In a contest between dependents, being the spouse and the children, and a non-dependent friend, the court's Section 26 power is practically more likely to cut back Joshua's share if necessary to make reasonable provision pursuant to Section 26 to 28 of the LSA Act. The fact the bequest was prompted by incessant begging is not illegality by itself, but it may be pleaded as part of a broader undue influence or suspicious circumstances narrative, though it still requires proof. Okay, so those are the key areas that the examiner expected to see from a student's perspective. So we have discussed on the validity of the will and its effect on the beneficiaries. Okay. Now, question 2. Mr. Dogo, a wealthy businessman based in Naivasha, died intestate 2 weeks ago, leaving behind flower plantations, dairy cows, cars, houses, and 5 billion shillings in Tajiri Bank. She was survived by 2 daughters, both married to wealthy men, and 3 sons aged above 18 years. Upon Dogo's demise, her two daughters applied for a grant of letters of administration, claiming that they were the only children of the deceased who was a widow. The letters were awarded to them and subsequently confirmed. The 2 daughters have been selling the property of the estate and sharing the proceeds to the exclusion of their 3 brothers. Currently, the 3 brothers have come to you for legal advice on the following issues. 1. The steps they should have taken to ensure that they were included in the list of beneficiaries when their sisters applied for the grant of letters of administration. 2. After receipt of the initial grant and before confirmation of the same, the steps they should have taken to stop confirmation of the grant. And C. Now that the grant has been confirmed, what steps should they take to ensure that they are not left destitute by the 2 sisters? So this question expects a student to have mastered the full steps of being issued of a grant of letters of administration, and when are objections listened to, and when is a revocation made, and when is a renunciation etc. made. So if we start with the step number 1, the step the brothers should take for them to be included in the list of beneficiaries when their sisters applied for the grant of letters administration. So question A, I answered it this way. they should have intervened early by entering an objection or caveat and or filing an objection to the petition, so the court could not issue a grant without hearing them as persons equally entitled. So if you read section 76 of the Law of Succession Act, a grant may be challenged or revoked where it was obtained by concealment of material facts or false statements. Section 76. I've pasted the provision before you. So that if you look at the judicial interpretations, Joe Oiche Oisembe versus Biliai Bosibori 2016, non-disclosure of beneficiaries and failure to involve them is a classic basis for revocation. So practical steps that they should have taken, because this is where the marking scheme is. File a caveat or objection in the succession cause immediately upon learning of it to stop issuance of a grant ex parte. Then file an affidavit of objection or protest stating that they are also children or survivors and demanding inclusion as beneficiaries and or as joint administrators. Remember, the question carried 2 marks. So the examiner wanted to see whether you know of this provision, section 76, and whether you know the steps to take at the petition stage. Then if you read B, it's saying that after receipt of the initial grant and before confirmation of the same, what steps should they have taken to stop now the confirmation of the grant that was coming to take place? So before confirmation, they should have moved the court to halt confirmation and to regularize administration by joining them as beneficiaries and typically as co-administrators, and sought preservation orders to stop sale or wastage pending determination. So confirmation is not automatic. The court must be satisfied the grant was properly made and the estate is being or the will is being administered according to the law. So this is where the examiner expected a student to cite section 71 of the Law of Succession Act. And the court can postpone confirmation where necessary, as the facts before you suggest. So practical steps that they could have taken post grant pre-confirmation stage. File an objection or protest to confirmation challenging the proposed distribution and non-disclosure. Then apply to postpone or stay confirmation under the court's power to delay confirmation until all beneficiaries are ascertained or heard. This is where you invoke section 71. Apply for preservatory orders, or where we have injunction restraining sale or transfer or charging, orders to render accounts, and where land is involved, seek restrictions or cautions through the court or land registry. Okay, that is another aspect that the examiner expects you to say, because this land is at risk. Okay, seek joinder or substitution of administrators, so administration is joint and accountable, or seek directions that confirmation must list all children and allocate shares lawfully. So the other aspect that the examiner wanted to see is that now that the grant has been confirmed, what steps should they take to ensure that they are not left destitute by the two sisters? So this is the last step. Now they have realized the grant is out. What can we do? So now that the grant is confirmed, they should urgently seek revocation or annulment of the grant and of confirmation, okay, for fraud and non-disclosure, plus interim protection, accounts, and the reversal or cancellation of transfers where possible. So the examiner expected to see section 76 of the Law of Succession Act, where revocation or annulment can happen at any time where the grant was obtained by fraud, concealment, or defective proceedings. So judicial interpretation is that where a petitioner excludes beneficiaries and allocates the estate to herself, the court will revoke the confirmed grant and reissue a joint grant. So revocation commonly comes with consequential orders, and the court can order fresh joint grant or cancellation of transfers or restriction to be filed. So the practical steps that the examiner expected to see is that you file summons for revocation. This is anchored under section 76, where you support the same by birth certificates proving that they are children of the deceased, evidence by the sisters, and then evidence of shares or transfers that has happened. Then seek urgent interim orders pending hearing, injunction restraining further sale or transfer charging of estate assets. Then you have seek consequential orders on revocation. This is where you can have fresh joint grant including one or more or brothers as co-administrators, setting aside the certificate of confirmation and fresh confirmation on a lawful mode of distribution, including all the 5 children. Then attack completed transfer or shares or sales. Then if dissipation is advanced, pursue tracing and recovery against the administrators personally as fiduciaries of the estate, and for orders compelling refund to the estate because it amounts to intermeddling if they went ahead to deal with the estate in a concealed manner. Okay, so let us look at the other question 4. Mr. Kiptasia died intestate 7 months ago, survived by 2 widows, Naomi and Charity. Naomi had 2 sons and Charity had 3 daughters. At the time of his death, Kiptasia had amassed a considerable fortune. The 2 widows and the eldest son applied for a grant of letters of administration in order to distribute the estate of the deceased, with no objection from the other members of the family. They agreed as to the distribution of the minor assets, which included personal and household effects, cars and animals. However, the problem arose during the division of the 1,000-acre piece of land in Transmingi, Kitale. Naomi and her 2 sons proposed that they should inherit 700 acres, while Charity and her 3 daughters inherit the rest. Naomi contended that Charity's daughters did not need a lot of land, since they would get married and subsequently inherit from their husbands. Charity found Naomi's proposal to be discriminative and instead proposed that the property be divided equally between the 2 families. Naomi refused to accept Charity's proposal. Charity, as a result, has come to you for legal advice and to give you instructions to take the necessary legal action to ensure that she and her children receive appropriate share of the deceased spouse estate. 12 marks. Advise her accordingly. So generally, Charity should move the succession court to reject Naomi's discriminatory proposal and have the 1,000 acres distributed strictly under the Law of Succession Act, counting all children, including daughters, and each widow as a unit. So Naomi's house cannot take 700 acres merely because Charity's children are girls. So these were the examiner was testing a candidate on the interpretation of Section 40 of the Law of Succession Act. So in a polygamous intestate estate, the net intestate estate is first divided between the houses according to the number of children in each house, plus the surviving wife as an additional unit in that house. Thereafter, distribution within each house follows. Okay, so in this situation, Naomi's house units will be counted as follows. Naomi has 2 sons, so that is 2 sons, plus Naomi herself, then that is 3 units. Then Charity's house, Charity has 3 daughters, plus Charity in her own capacity, that is 4 units. So in total, we have 7 units. So the ratio of division is that Naomi's house will get 3/7, Charity's house will get 4/7 of their 1,000 acres, subject to proof that the land forms part of the net intestate estate and any prior gifts or settlements if raised by any party. So courts often apply Section 40 and reject attempts to exclude daughters from inheritance in polygamous estates. So this is in the case of Joseph Mwangi Thiongo versus Francis Mwangi Thiongo 2014, where the court held that the Law of Succession Act, specifically Section 40, governs the distribution of an intestate estate in a polygamous family. The estate must be divided among the houses according to the number of children and surviving wives, with no discrimination based on gender. The court found no valid will or lawful document expressing the deceased wishes to exclude daughters from inheritance. Any purported wishes or notes to contravene statutory provisions cannot be enforced, and the court also found no evidence of a valid renunciation by the daughters, and the court had to give consequential orders in regards to that property. Married daughters cannot be shut out merely on the argument that they will marry and inherit from husbands. This is treated as unlawful discrimination in succession, as we see in the case of Emma Kiugu versus Joseph Kiugu 2015. Okay, so what to do? File a protest or an affidavit of protest to confirmation or to the proposed mode of distribution if confirmation is pending, insisting that distribution of the 1,000 acres follows Section 40 and that daughters' shares are equal to the sons' shares. Then you propose a lawful mode of distribution in the protest. as we have discussed, 3/7 and 4/7. Within Charity's house, her life interest in her house share with the three daughters as beneficiaries thereafter. The court typically structures this to prevent disinheritance and to reflect Part 5 of the Act. Then seek preservatory orders pending determination to stop the subdivision, transfer or sale of the 1,000 acres while the dispute is still pending. Then ask the court for directions on subdivision mechanics. Do you have survey mutation and land control board where applicable, so that the decree is implementable. Okay, so 5. If Naomi alleges girls will marry or any custom, challenge it as irrelevant where the Act provides the rule and insists on statutory distribution. If the grant is already confirmed on Naomi's proposal, Charity should apply to set aside or review the confirmation and revoke the grant on the basis that the distribution is unlawful and discriminatory, and seek immediate preservatory orders. Question 5. We have Section 3(5) of the Law of Succession Act has been rendered redundant by Section 6 of the Marriage Act 2014 Anonymous. With the aid of the Law of Succession Act and the Marriage Act, as well as case law, critically discuss the above statement. So my answer was no. Section 3(5) of the Law of Succession Act is not redundant. Section 6 of the Marriage Act classifies marriage to include monogamous and polygamous setups for validity and capacity during the life. Section 3(5) of the Law of Succession Act remains a succession protection provision that can still recognize a woman as a wife for inheritance purposes in polygamy permitting systems, even where the deceased also had contracted a statutory monogamous marriage, but this is subject to proof of the marriage or presumption of marriage being raised. Section 3(5) of the Law of Succession Act, in substance, it deems a wife for purposes of the Act a woman married under a system of law permitting polygamy, even if the man had contracted a monogamous marriage under written law, so long as the woman proves the customary or polygamous marriage or a presumption of marriage where applicable. Because Section 6 of the Marriage Act 2014 recognizes various types of marriages to include Christian, civil, customary, Hindu, and Islamic marriages. And their nature is that some are monogamous, customary, potential, polygamous, and generally regulates capacity and validity of marriages. So the tension is resolved by treating Marriage Act as governing capacity or validity of the marriage, while Section 3(5) governs status for succession. This is a distinct angle of looking at this dispute. If you read the case of Irene Jerry Macharia versus Margaret Wairimu Njomo, 1996, Section 3(5) was enacted to cure the pre-1981 mischief of excluding customary wives where a statutory marriage was existing, but the customary marriage must still be proved on evidence. If you read the case of Hannah Wanja Waruiru versus Anna Muihaki Waruiru, 2014, is that we can say that the ratio decidenda was that the court found that the applicant established on a balance of probabilities that she cohabited with the deceased for 10 years and she was acknowledged as his wife. Despite the respondent's statutory marriage to the deceased, Section 3(5) of the Law of Succession Act recognizes the applicant as a wife for succession purposes due to the polygamous nature of the Kikuyu customary law and the presumption of marriage from long cohabitation. The respondent failed to disclose the applicant's status as a dependent when petitioning for the grant, amounting to concealment of material facts. Consequently, the grant issued to the respondent was revoked and a new grant was ordered to be issued jointly to both the applicant and the respondent. So this was also corroborated in the case of Christopher Geoffrey Roselle in Dure 2021. But Section 3(5) is not a free pass. If the alleged customary marriage is not proved, the claimant is not treated as a wife for succession. So this is also another argument that the examiner expects to see a student taking. Priscilla Ruguri Gathigo versus Virginia Kanungu Gathigo, 204. The court found that while the petitioner was lawfully married to the deceased under the Marriage Act and had 9 children with him, the protester failed to prove a valid Kikuyu customary marriage to the deceased. The evidence presented by the protester, including testimony from her daughter and brothers, was insufficient to establish the essential customary formalities required for a valid marriage, such as the slaughter of a Gurario ram and the involvement of elders from the deceased family. The court also found that the birth certificates and school records produced to prove paternity of the protesters' children are unreliable, and they were obtained after the deceased's death and contained inconsistencies. Consequently, the protester and her children were not recognized as beneficiaries or dependents under the Law of Succession Act. So Section 3.5 is not a free pass. So we can say that in summary, Section 3.5 of the LSA and Section 6 of the Marriage Act poses different questions and requires different interpretations. Okay, was there a legally valid marriage? Was it monogamous or polygamous? Did the parties have capacity to marry? That is the question being posed by Section 6 of the Marriage Act. Then Section 3.5. Assuming the union is of a type permitting polygamy or proved or presumed, should the woman be treated as a wife for succession to prevent disinheritance? That is Section 3.5. If Section 6 of the Marriage Act were read to exclusively determine who is a spouse for all purposes, then any later union contracted contrary to capacity rules would automatically be ignored in succession. Yet, Kenyan succession courts have repeatedly still invoked Section 3.5 to include such women as wives for inheritance purposes. So that the continuing line of authority shows Section 3.5 still does work after the Marriage Act regime was promulgated. It prevents the estate being administered on the formal monogamy-only view where justice of succession is involved. There are some limits that were brought after the Marriage Act 2014, is that the Marriage Act strengthens arguments on lack of capacity to contract a second marriage during a monogamous marriage. But succession courts distinguish capacity and validity from dependency or recognition for inheritance purposes. Okay, so that is the key takeaway that the examiner expected you to cite. Then question 6. Mr. Nima, a businessman, went to South Sudan to carry out a sugar business. His business flourished until December 2014 when the South Sudan rebels started destroying businesses belonging to foreigners. 5 months ago, his shop was attacked. Before the attack, the business people were advised that armed snipers were approaching their area. At this juncture, Nima told his shop assistant that if he, Nima, was killed, his uncle Maini should inherit his property. At about 7 p.m., the attackers arrived and Nima was shot dead at close range. After Nima's burial, his uncle Mainani went to court to petition for grant of probate. However, Mr. Nima's father, Mzee, challenged the petition, claiming that his son had died intestate without a spouse or children and that he, Mzee, was the rightful applicant. Mzee therefore plans to apply for a grant of letters of administration in order to administer Nima's estate. Nima left several houses in Nairobi, which Mzee had been taking care of and collecting rent during his son's absence. Secondly, Nima, as his only son, used to support him as Mzee's wife had died 2 months previously. Mzee has come to you for legal advice. Advise him and the action he should take to protect his interest at 12 months. Mzee should immediately stop Mainani's probate bid by challenging the alleged oral will to be invalid and unproved, and in parallel, move the succession court for 1. Preservation orders seeking control of the Nairobi rental income, and 2. His own appointment as an administrator, because he is the father. The father has priority if intestacy is found in this situation. So the governing rule that the examiner expects is that to see Section 9 of the LSA Act on oral wills. An oral will is only valid if made before 2 or more competent witnesses and the testator dies within 3 months of making it. Then Section 66 of the Law of Succession Act, who should administer if intestate. If intestacy, the court gives preference to certain persons to administer. A parent has priority over an uncle. That is also another key point that the examiner expected to see. Then, Section 26 of the Law of Succession Act. If a will, including an oral will, leaves a dependent without reasonable provision, the court may order reasonable provision out of the estate. So courts have strictly enforced Section 9 requirements of the 3-month rule and the 2-witness rule. If not satisfied, the deceased is treated as intestate. This Simon Wairagu Githai versus Albert Njeru Githai 2019, where the Court of Appeal found that the alleged oral will was invalid under Section 9 of the LSA Act because the deceased died more than 3 months after the date of the purported oral will. Consequently, the deceased died intestate, and Section 38 of the LSA Act therefore applied, requiring equal distribution of the estate among all surviving children. The court held that the trial judge was correct in rejecting the oral will and in ordering equal distribution, as the law does not allow exclusion of a child from inheritance in the absence of a valid will, regardless of any alleged bad blood or misconduct. The appeal was dismissed as lacking merit. Then, James Ndungu Dhungu versus Martin Ndi Gateru. The court found that the alleged oral will did not meet the requirements of Section 9(1) of the Law of Succession Act, as there was no evidence it was made before 2 or more competent witnesses, and it was allegedly made 2 years before the deceased's death. The court further determined that the respondent had illegally subdivided and registered the estate property in his own name before confirmation of the grant, which is contrary to the law. So even where oral wills are alleged, proof must be clear and consistent from competent witnesses. Courts reject ambiguous instructions that are not truly testamentary. So what are the steps that the examiner was expecting to see from a candidate? So Mzee should file an objection or answer in my nanny's cause. So Mzee should file an objection in my nanny's case and a cross application if needed, stating that there is no written will, so probate is misconceived, and that the alleged oral will is invalid or approved under Section 9 of the LSA. Then he should attack the oral will on evidence. Then, petition for grant of letters of administration intestate in Mzee's name if the oral will collapses, relying on the court's preference under Section 66 of the LSA Act. So many students will file an objection attacking the oral will, but the question demanded 12 marks. So you should proceed to do a petition for grant of letters of administration intestate to be given in Mzee's name if the oral will collapses. Okay, this is where you invoke the court's inherent power, Section 66. Then you seek immediate preservation orders over the Nairobi houses on rent, orders that all rent be paid into an estate account or court control account. If in the worst case scenario, the oral will is upheld, file a dependence claim for reasonable provision under Section 26, proving Mima maintained him. Okay, wife recently deceased, only son ongoing support, and seek monthly maintenance or a lump sum or asset allocation from the estate. This is where many students also lost marks, in that they only advised Mzee on how to counter the oral will. Okay, that forms the majority of the marks. But in the worst case scenario, if the oral will is upheld, what will Mzee do? Mzee will proceed to file a dependence claim for reasonable provision under Section 26. Because from the facts, we can say that the wife has recently died. He is the only son, therefore Mzee is ongoing support from his only son. So those are the nitty-gritties that a student ought to have noted. Question 7. Present a critical analysis of the following. The requirements of satisfactory system of trust accounts under the LSA Act and the length of time. The requirements of satisfactory system of trust accounts under the LSA Act and the length of time such accounts should be kept upon distribution of the estate of a deceased person. And 2, the rights of beneficiaries in respect of the estate accounts before distribution to the estate. I'm coming. So one thing we can say is that this question is technical. So the examiner expected a student to have analyzed this act, because if you read out the answer, a personal representative must run the estate like a trustee. He should segregate estate funds, keep complete source documents, file the statutory or inventory or accounts when due, and be able to justify every receipt, payment, and distribution. The Law of Succession Act does not fix a post-distribution or retention period. Practically, he should keep records at least for the month in which the court can still be moved on accounts or revocation and for ordinary civil limitation or audit needs. If you read out the governing rules that the examiner expected to see, we have Section 84 of the Law of Succession Act on fiduciary or trust character of administration. Personal representatives may become trustees where continuing trust arise, e.g., minus and life interest. Okay, so this is where we can say the first answer will lie to. Personal representatives may become trustees where continuing trust arise. Then, Section 41 of the LSA. Property devolving to a child is held in trust until statutory conditions, e.g. attaining the age of 18, are met. This is Section 41 of the LSA Act. Then, point number 2. The examiner expected to see Section 95 of the LSA Act. This talks about accounts or inventory to being tied to statutory duties. The Act imposes a duty to produce inventories and accounts. Failure to produce the same is criminalized. If you see Section 95 1b to c, this will be an offense. It will be an offense to fail to produce or to produce false accounts. Okay, this is Section 95 of the LSA Act. Then Section 75A of the Law of Succession Act, as read together with Section 81 of the Law of Succession Act, is that where a continuing trust exists and only one administrator remains, court involvement is mandated to include additional administrators. Because you have said on continuing trust is where we have minus or life interest, and basically the court requires 2 administrators. So in any situation where only one administrator is remaining, the court is mandated to involve an additional administrator. So there are some judicial interpretations surrounding this issue. If you read the case of Inri Estate of Dishon Mdala Agola 2021, where the court ordered administrators and the advocate to render proper accounts where sale proceeds could not be reconciled. And the duty to account is statutory and collective. Court can compel inventories and accounts and bank statements. Even after transmission and distribution, an administrator, including a spouse, may still be compelled to account. Transmission does not equal absolute ownership. That was the case of Inri Estate of Amos Shege Kamiede. So, a practical answer that the examiner expected, because to bring you on board, the question read directly as that: present a critical analysis of the following. 1. The requirements of satisfactory system of trust accounts under the Law of Succession Act and the length of time such accounts should be kept upon distribution of the estate of the deceased. And 2. The rights of beneficiaries in respect of the estate accounts before distribution to the estate. So part A, what is a satisfactory system? It has not been labeled in the Act. It is what would enable compliance with Section 83, where we have inventory and accounting duties and withstand a beneficiary or court challenge. In practice, it means 1. Segregation of estate monies. This is where a personal representative should open and operate an estate account not a personal one. Courts routinely order rent and income to be channeled through a controlled estate account where disputes exist. Okay, this reduces commingling risk and evidences fiduciary discipline. That is marking point number 1. Marking point number 2, complete audit trail. Maintain bank statements, deposit slips, receipts, invoices, sale agreements, completion statements, valuation reports, schedule of distribution and beneficiary acknowledgements. Every transaction should be traceable from source to the beneficiary receipt. Then marking point number 3, we have periodic reconciliation and disclosure readiness. Reconcile estate cash book versus bank statements. Maintain a running statement of assets and liabilities and income expenditures. Keep a distribution schedule showing assets and beneficiaries, etc. Marking point number 4, trust overlay where continuing trust exists. So where minors and life interest exist, we are functionally a trustee pursuant to section 41 and 84 of the LSA. So you must keep trust style accounts until the trust ends. So this is where minor attains the age of 18 and the property is transferred to him or her. So remember, the examiner asked you to give the timelines when this trust will end, when this accountability will end pursuant to section 83 and 84. So these are the examiner will be looking at. Do you understand the concept of continuing trust? Do you know when the same will lapse? Okay. Then, how long should accounts be kept after distribution? The Law of Succession Act does not describe a specific number of years to retain the estate or trust accounting records after distribution or filing of final accounts. This is because courts can compel accounts and sanction administrators for failure or falsehood, pursuant to section 95 as we have seen. Records should be kept long enough to defend any later challenge, e.g. disputes over omitted assets, rental collections and sale proceeds or alleged intermeddling. In practice, advocates commonly advise at least 7 years at a risk management minimum level. What are the risks to estate accounts before distribution? These required 4 marks. Benefits are entitled to demand and, if necessary, obtain court orders compelling full inventories and accounts before distribution. The administrator is accountable to them and to the court. Section 95 of the LSA. Beneficiaries' entitlement flows from the administrator's statutory obligation to render inventories and accounts. Where the estate is held on continuing trust, beneficiaries have trust-type rights to transparency and proper stewardship. This is provided for under Section 41 and 84. Beneficiaries have locus to seek accounts from administrators under the Law of Succession Act, and courts will compel compliance. Then courts will order detailed accounting of the same. So practical application to the answer. Access to filed inventories and accounts and supporting documents, court-compelled accounts, protective orders pending accounts, and consequences for non-accounting. That was a technical question, and the examiner expected a technical approach to the same. Question 8. As the personal representative of the estate of Jonah Kabira, which has 1 tenant for life and 4 remainder men, explain how you will apportion the funds described below. 1. A sum of 100,000 received by Kabiria from one of his tenants on the eve of his death. 2. A sum of 2 million received months after Kabira's demise in respect of a block of flats. Then C. A sum of 5 million being proceeds of a life insurance policy paid out upon Kabira's death. This was also technical. Remember, this is a 2015 question paper. A portion of the income or capital divide. Amounts that are income attributable to the life period go to the tenant for life. Amounts that are capital or death benefits not forming estate income go to the remainder men or to nominated persons if outside the estate. 2. For rent or lease payments, apportioned by time. Pre-death accrual is capital to the estate. Post-death accrual is income for the life tenant. So this was a bit technical, so we delve deeper because I have given out the answer below so that we understand clearly. Life interest regime. Surviving spouse or life tenant takes a life interest in the residue. Children or remainder men take the capital after determination of the life interest. This pursuant to section 36 of the LSA on the life interest concept. The parallel operative provision is that spouse plus children cases will fall under section 35. Then, trust overlay for remainders. Where property devolves subject to a minor's entitlement or continuing trust, it is held in trust until vesting. This is pursuant to section 41 of the LSA Act. We have seen some decisions. A life tenant, typically the widow or the widower, is entitled to exclusive benefit of the income, e.g. rent, during the life interest. And remainderment's rights crystallize after life interest ends. This is the estate of Jonah Thumbi 2022. Courts will enforce the structure that the life tenant enjoys, the estate during life interest, with remainder men taking thereafter. Disputes are resolved by applying the life interest provisions strictly. This is Louis Nyangudi Maina, 2016. What the examiner expected. 100,000 received by Kabira from a tenant on the eve of death. Treat it as accrued income up to the date of death. Capital of the estate. This is not a post-death income. If it is rent or arrears for a period before death, it is part of the deceased property at death. So, estate capital, ultimately for the remainderment, subject to the life interest structure, i.e., it is not income arising during the life tenancy. It already accrued to the deceased. 2. If it was advanced advance rent covering a period after death, apportion the following: pre-death portion to capital, post-death portion to life tenants as income because you have used time apportionment. Okay, if it is before the death of the deceased person, that will form capital of the estate. If it is in advance, post-death portion, this will lead to a pre-death portion to capital pursuant to time apportionment analysis of the same. Then 2 million received months after death in respect of a block of flats for lease for marks, apportioned by what the payment represents. 1. If it is rent or lease accruing after death, e.g. monthly rent or periodic lease payments for the period after death, it is income of the estate during life interest. So you pay or apply it for the tenant for life, consistent with the Jonah Thumbi decision on rental income. 2. If it is a premium or consideration for granting a lease or a capital transaction, e.g. lease premium or surrender value, key money sale of leasehold interest, that is capital. Preserve as corpus for the remainder men. Life tenant should enjoy income, not consume capital unless the instrument or court permits. If it is a mixed receipt where we have premium and rent element, split accordingly. Premium to capital, rent element to income. 5 million life insurance proceeds paid on death. Default position is that life insurance payable on death goes to the nominated beneficiary and does not form part of the free property of the deceased. Only if payable to the estate does it fall into the estate. If the policy names a beneficiary or nominee, pay directly to that beneficiary outside the estate apportionment. Neither life tenant nor remainder men share unless they are nominee. 2. If payable to legal personal representatives, it becomes estate capital, held subject to the life interest arrangements. Ultimately, for the remainder men, life tenant may only take income generated from investing it, not the principal. So if we read the opening statement for us to have the key takeaway from such questions. A portion on the income or capital divide. Amounts that are income attributable to the life period go to the tenant for life. If it is an income attributable to the life period of the deceased person, this will go to the tenant for life. Amounts that are capital, death benefits, not forming estate income, go to the remainder men or nominated persons if outside the estate. For rent and lease payments, apportioned by time. Pre-death accrual is capital to the estate. Post-death accrual is income for the life tenant. This is a direct interpretation of Section 36 of the LSA Act. And various decisions as we have seen. Higher. 9. A personal representative is considered as more than a mere administrator of a deceased property entrusted to him. He is allowed to invest the trust fund as part and parcel of the management administration of the trust property. Discuss. So basically the question wants to test whether a student has understood the difference between a personal representative and his duties beyond a mere administrator of a deceased property. The question tests on investment of trust funds and management and administration of trust property. So yes, a personal representative is a fiduciary or trustee, not a mere administrator, and may in some cases must invest estate or trust monies, but only within the statutory framework for proper estate purposes, e.g. preserving value, providing for legacies, continuing trust, with full accounting and without self-dealing or unauthorized risk. Section 79 of the LSA. Estate vests in the personal representative. Once a grant issues, the deceased property vests in the personal representative in that representative capacity, giving them management powers but subject to fiduciary duties. 2. Powers plus duties are statutory, not personal discretion. Section 82 says, the personal representative has powers needed to administer the estate, collect, manage, and pay liabilities, and also distribute, but must stay within the Act and the grant. Section 83 still says they must render inventories on accounts, and failure, if there is likelihood or failure to do so, it attracts a criminal liability and criminal sanctions pursuant to Section 95 of the Act. Investment is expressly contemplated and required in specific situations. On legacies, Section 90 of the LSA. Personal representatives shall invest funds set aside to provide for legacies as per the 7th schedule. Legacies are debts. 4. Where there is a continuing trust, personal representatives become trustees. If administration involves continuing trust, where we have life interest and minus etc., personal representatives are the trustees unless other trustees are appointed. This is under Section 84 of the LSA Act. So personal representatives are fiduciaries holding estate property for beneficiaries, and courts compel strict accounting and proper stewardship. Why a personal representative is more than an administrator? This was the marking scheme. Under Section 79 of the Act, the PR becomes the legal holder of the estate property, but not for personal benefit. Their role is fiduciary because of the following marking points. They control other people's beneficial interest. These are the beneficiaries and the heirs. They must act for proper purposes. They pay debt, expenses, and preserve and distribute. This was the point on legacies. They must account and be surcharged and removed for breach purposes. There is an angle of accounting that also comes into play. Investment power. Investment is a management tool, not a profit opportunity. The Act positively requires investment for some funds, legacies under Section 90, and treats personal representatives as trustees where there is a continuing trust. Practically, investment is justifiable where 1. Funds cannot be immediately distributed pending confirmation or disputes, preservation against inflation or wastage is needed, and the court has directed funds to be held in an interest-earning account. But investment is not a license for speculation or a license to mix estate funds with personal funds, because you saw that the law requires them to have a separate bank account for the estate income. The standards that control how investments must be done. So, authority, you act within the grant and Section 82 powers where Section 90 applies and comply with the 7th schedule. Transparency, keep records and render account on request and in case of a court order. Then, what was the second question demanding? The second question, the other element of it was how to manage how management and administration of the trust property. The question demanded 12 marks. So we are still answering the question, but in a split mechanism. So what practical steps should a personal representative take when investing estate funds? Identify the legal basis. Is it legacy money? Is there a continuing trust? Is the grant confirmed? Segregate funds. Open an estate account in the estate name. Then document decision making. Do you have consents and minutes? Then account periodically, where we have receipts and interest earned and taxes and how funds are applied. Anticipate a court-ordered accounting. So basically that was how students were required to tackle question number 9. So if you are keen, 2015 probate question paper could have gotten many students off guard, because rarely do students read the interpretation of the Act when it comes to the trust element of it. Because if you see question 10, you are the administrator of the estate of Juma Bakr, the deceased. Prior to confirmation of the grant of letters of administration, one of the beneficiaries of the estate approaches you to loan him a sum of 4 million from the estate to buy a car. You're the administrator. Then a beneficiary approaches you to loan him 4 million to buy a car. How will you deal with the request and why? 3 marks. Show how you would reflect the sum in the memorandum, schedule of assets, and cash account. Suppose the account with adequate funds to loan the beneficiary is held in a foreign bank within a Commonwealth country. Explain how you will access the same in order to loan to the beneficiary. And D, will your response to the request be different if Juma Bakar had died tested? And lastly, E, how will you deal with the request and why? That is a repetition. Now answering part A. Okay. Remember the other time that we saw the examiner expecting a student to draft a memorandum and a schedule of assets was back in 2012. So we can see some elements of the historical aspect of asking questions being asked but tied up to various questions. So how will you deal with the request and why? Decline to loan the 4 million from the state capital before confirmation. If at all, only consider an application of post-death income, not capital, or seek a specific court order or direction. Why? No distribution of capital before confirmation. A loan to a beneficiary from estate funds is in substance an advance distribution of estate capital and is barred pursuant to Section 55 of the LSA Act. This is why we told students to have an analysis of what capital entails and what post-death income entails. Because if it was an income, if the deceased was earning a certain income, then the child or the beneficiary could have been loaned only pursuant to the income, because the law states, Section 55, no distribution of capital before confirmation. If the deceased person has died with no passive income that is advancing even after his death, that is not income, but that is capital, and you can't transact. Intermeddling or unauthorized dealing risk where you part with estate property otherwise than for due administration. This is pursuant to Section 45 of the LSA Act. Courts have gone ahead to treat pre-confirmation transfers and dispositions as unlawful and void. Okay, that is the marking scheme that the examiner expected a student to have stated. Remember, the question wanted 3 marks. So you decline. Do you have the provisions? This amounts to capital before confirmation. 1 mark. 1 mark above. Intermeddling. You are aware of intermeddling. 1 mark. How to reflect the sum in the memorandum, schedule of assets, and cash account. 5 marks. Okay. I am receiving a call in a few. Hello? Hello? Yes? Oh, asubuhi. Let me go asubuhi first thing in the morning. But after quarter minute. Yes. Okay. So thank you for your indulgence. How will you reflect the sum in the memorandum, schedule of assets, and cash account? So assuming the request is recorded as requested but not paid by pursuant to our previous recommendation on refusal. If hypothetically a court has authorized it and you advanced it, it must be shown transparently as an estate receivable. Memorandum. Loan advance to beneficiary and confirmed. Beneficiary name, amount, authority, terms, interest if any, repayment date, security if any, status, outstanding, repaid or in default, accounting treatment, estate receivable, not distribution. Okay, so these are the nitty-gritties that the examiner will look at. Do you know that that will form part of estate receivable, estate debt, but it is not full distribution? Okay, have you given out the names? Under what authority? That is what will go to the memorandum. Schedule of assets. If not paid, no change to assets. Cash remains cash. Add a memorandum note only. If paid under authority, include as an estate asset. Debtors or loans receivable, we have beneficiary advance of 4 million. Cash account, if not paid, no entry, again, not only. If paid, authorized via the authorized mean, payment credit, advance, loan to beneficiary, closing balance reduces accordingly. Remember, this knowledge will be taught in LPM accounting, where we will be drafting cash accounts, bank statements, and balancing the same. So the examiner expects a student to apply the knowledge of accounting in a brief manner. Do you know that if you issue out a loan, you must record it in the schedule of assets, whether the same is adjustable? Okay, so those are the nitty-gritties that the examiner expects to see. Do you know that the closing balance will reduce accordingly if you have advanced this amount to this person? Okay, because under the schedule of asset, one asset that you will be taught is an asset known as a cash account. We have cash at hand. Okay, so these are the things that the examiner will be expecting to see whether you can interpret. That carried 5 marks. Then, suppose the account with adequate funds to loan the beneficiary is held in a foreign bank within a Commonwealth country. Explain how you will access the same in order to loan to the beneficiary. Remember the rule of resealing of foreign grants. You will first obtain authority recognized in that jurisdiction to operate or withdraw from the foreign account. Kenyan Probate Authority generally does not automatically compel a foreign bank to release funds. Practically, now this is where the marking scheme is because it is 2 marks. Instruct a counsel or agent in that country to reseal the Kenyan grant or obtain an ancillary grant, then give the bank the resealed grant, plus know your client details, plus board or administrator resolution as required by the bank to remit to the estate account in Kenya. So that is it. You have to follow the procedure that is to be followed in that country because it is a Commonwealth country. Would your response have been different if Juma Bakar died testate? Okay, testate, he has a will. No, still generally refuse a pre-confirmation loan out of capital. Even with a will, estate capital is not to be distributed or advanced before confirmation. The safer position remains no loan unless a specific will clause plus lawful authority or court direction supports it. The key difference is timing and authority. Probate relates back to death. Intermediate Executor Act may be validated, but that does not convert a beneficiary car loan into a proper administration expense or make Section 55 irrelevant. Section 80 of the Law of Succession Act, probate effective from death, letters of administration effective from a grant. That is the key takeaway of Section 80. Probate is effective from death and letters of administration is effective from a grant. This marks the end of the Probate and Administration Paper 2015 series. Key takeaway: the students who sat for this paper and they went with general knowledge on who is a wife, who is a divorcee. The question took an inclination majorly to the trust management part of it, to an extent of testing a student's interpretation of accounting principles and fiduciary duties of the personal representatives, and basically how you will distribute intestate properties pursuant to Section 40 of the LSA. The examiner expected to see the ratios of units, how you identify units of a certain lady and children being applied in real time. Another key takeaway is that from this question, we have realized that the examiner expected a student to give practical steps of when to file a document, when to file for summons for revocation, when to file for objection, when can you seek for renunciation. Okay, so they were testing various stages of the grant letters of administration procedure. They also tested whether a student will know that you have to seek interim orders as part of your analysis. Okay, we have also seen a situation where somebody has Mzee, the name that was used in the question was Mzee. Mzee had moved to revoke an oral will, but some students will leave out after the will has been declared not to be legal after the test that has been outlined under the LSA Act, Section 9. Okay, then they forget to tell Mzee what now to file after the will has been declared illegal. So we encounter situations where students end up scoring half the marks allocated because the question carried 12 marks for lack of properly or fully advising the client on some aspects of it. So this is 2015 series. Once we are done with 2015 series, you will notice that I have jumped all the way to 2023 and 2021 now on the papers that are with the highest scoring elements and the lowest scored papers, so that we analyze and take note of irrelevant information that people usually write in answering some questions, and what the best of the best usually write in such situations, and what the marking scheme actually said. Okay, so those are the nitty-gritties that we want to merge. When it comes to immediately after we are through the 2015 series, we embark to 2021 and 2023 because those are the analyzed papers. They were available in the website. Then, if you are keen, you have also noted a swift transition to analysis of the course outlines. So far I have analyzed LPM, I have analyzed a conveyancing, I have also analyzed, so far those two. And the reason I'm doing this is because when it comes to the oral sessions, the examiners will have a schedule of the units and the current position of each and every class. So there is an expectation of a certain scope. And in this expectation, there are some questions that they expect. If a student duly attended the classes, they should answer pursuant to the course outline. So the course outline is one of the tools that is before them. So we can't ignore the course outline for purposes of orals and purposes of mental preparations of the exams. Because some course outlines also reveal a procedure. Like for the criminal course outline, if we have discussed extradition proceedings, we know and we know, so there is no turning back. Mergers and acquisition, we will have captured everything, okay? So that is it. Course outline is part of the process, but they are running simultaneously so that we fall into the bracket. Then another strategy that you have still identified is the analysis of the various legislations. I'm done with the SOPEC rules, the digest, where I've analyzed a rule, case law, and the test that emanates from that rule, so that when you are faced with any professional ethics question, you have the Advocates Act on one hand, and you have the SOPEC rule on the other hand with case laws and tests. That will be enough to counter that paper adequately. Then the analysis of the acts will form simultaneously with the analysis of the course outlines. We have judiciary orals, that is best left out for weekends. Saturdays, full Saturdays are oral sessions. Then Sundays, these are a merger of the various elements. So thank you, Victor Muteti, for your attendance as we continue to digest these papers adequately. Thank you. There was recording the same. Do you have any feedback? Okay. I've seen your thumbs up. So thank you so much. I can end the recording and upload in YouTube. Thank you. Thank you. Thank you.